Today on Go Ahead Ask, have you ever wondered how Walt Disney acquired all of his land in Florida without anyone knowing? There are so many benefits of a title holding trust, also referred to as a land trust, but there's also so much misinformation out there. Let's unravel that today on Go Ahead Ask.
Building wealth in real estate? Let the Exeter Group take the mystery out of how it's done on Go Ahead Ask.
Welcome to the Go Ahead Ask podcast by the Exeter Group, where we unravel the mystery of investment real estate to provide investors with better quality information so that you can make better informed investment decisions. I'll be your host today. My name is Bill Exeter. I'm the Chief Executive Officer of Exeter Trust Company. And the Exeter Group of companies includes Exeter 1031 Exchange Services, which serves as a qualified intermediary for 1031 exchanges. They administer all types of 1031 exchanges in all 50 states. And then Exeter Trust Company, which serves as custodian for self-directed IRAs and self-directed individual 401ks, as trustee for title holding trusts or land trusts, as escrow agent for specialty holding escrows, and also as custodian for specialty custody services. Here on Go Ahead Ask, we always encourage questions or topics, or even if you'd like to appear on Go Ahead Ask, you can email us at ask@exeterco.com, or you can call us at area code 619-239-3091. Again, that's area code 619-239-3091. And if you love Go Ahead Ask, please like it, subscribe to it, and share it with your friends and family. Today on Go Ahead Ask, we're going to unravel the mystery of title holding trusts or land trusts. There's more than ever, there's so many reasons why you might need to buy, hold, exchange, and sell real estate in a confidential and private manner. This is just one of the many benefits of using a title holding trust or land trust. And we're going to unravel that mystery today on Go Ahead Ask. First, I thought we might want to do a quick history of what a title holding trust or land trust is. And they actually date back to the 1500s, if you can believe that. They go back to King Henry VIII times. Back then, if you were a property owner, your sons would have to serve in the military. So they would set up a land trust to hold title to the real estate so that nobody knew they owned the land, and therefore their sons wouldn't have to serve in the military. So going back to the 1500s, it was still at that point designed for confidentiality and privacy of ownership. It was introduced into the United States back in the late 1800s by Chicago Title and Trust Company in Illinois. So that's why you often refer to it termed or referred to as an Illinois land trust, because that's where it first came into being here in the United States. In fact, 49 states, they probably call it a land trust. And here in California, they refer to it for the most part as a title holding trust. We actually coined that term back in the early 1990s because we would have folks that would call us and say, I really want to hold title to real estate in a confidential and private manner, but I don't have land. And so they thought that it had to be land in order to use a land trust, which is not the case. It's designed for any type of real estate or even personal property. So we kind of coined the name title holding trust because that's effectively what it does, is hold title to real estate. So you'll hear people call them title holding trusts, land trusts. You even refer to people or hear people refer to them as blind trusts or business trusts, which they are not. They're not a blind trust. They're not a business trust. That's a different type of an animal, but that's what people refer to them as. But the primary purpose of this is to hold title in a confidential manner. So what does your title holding trust do for you? Well, first of all, it's a trust agreement that you draft, and we would draft that for you. It is not recorded. It is not on public record or on public title or anything like that. The title holding trust agreement or land trust agreement is fully revocable at any time. You can terminate it, you can amend it, you can revise it at any time, even after death. This is unlike a living trust, which becomes irrevocable at death. With a title holding trust, it will pass on to your heirs, but it is not irrevocable. So even when you pass on, your heirs can revoke the title holding trust if they want to. It's a grantor trust, just like a living trust, which means a number of things. It's very similar to a living trust, but there's some big differences, so we'll talk about that. It's a pass-through entity, which means anything from a tax perspective that occurs inside of your title holding trust is passed through to your individual or the beneficiary's tax return. So if you're an individual, it's a pass through to your 1040 tax return. If you're an entity, it'll be passed through to the entity's tax return. The title holding trust is also considered a disregarded entity. So that means it exists and it gives you some estate planning benefits and other benefits that we'll talk about. But for tax purposes, it's completely ignored. That's both of the pass-through entity and especially the disregarded entity is critical. And we'll get into more details as to why. So first, let's talk about the parties. The person who's actually going to set up the title holding trust is the trustor. In some states, it might be called the grantor or the settlor, but that's the person that's going to set up the title holding trust. Then you have a beneficiary. Now, this is where it gets different from a living trust. With a living trust, let's say husband and wife set up a living trust. They are the trustors or grantors of the trust, and they own and control the trust. They name, let's say, their kids as the beneficiaries. In that case, the beneficiaries, the kids, do not have a current interest. There's no present interest in the trust. It's a future interest upon the death of both parents. With a title holding trust, that is not the case. The trustor is the one who sets up the trust. However, you designate a primary beneficiary, and that's truly the owner of the trust. Now, in most cases, the trustor and the primary beneficiary will likely be the same person, but the primary beneficiary is the one that has a present or current interest in the trust. They own whatever's in the trust. They would also designate a successor beneficiary. God forbid something happens to the primary beneficiary, who is going to inherit that trust upon death. So you would also want to name successor beneficiaries. Now, the successor beneficiaries do not have a current or a present interest in the trust. That is the future interest. So upon the death of the primary beneficiaries, the successor beneficiaries would take over. And if they wanted to, they could terminate the trust at that point in time. Then you also designate a trustee. The trustee of a title holding trust or a land trust can be any individual or any entity of any type. In most cases, when you're looking for real confidentiality and privacy of ownership, you'll use a company like Exeter Trust Company. Now, with the title holding trust, the trustee has absolutely no control over the trust. They have no discretionary authority. They cannot make any decisions. The primary beneficiary has complete ownership, complete control over the trust, and has to give the trustee direction to do anything. So it's very different than a lot of other trusts out there where the trustee has the authority to manage the assets in the trust. With a title holding trust or land trust, they do not. Only the primary beneficiary or the beneficiary that's currently the primary beneficiary has the ability to direct the trustee to do anything with the assets inside of the trust. The primary beneficiary could appoint somebody as the power of direction. Perhaps they're going to leave the country on a vacation for a few weeks and they want someone else to be able to give the trustee direction. So they could appoint somebody or some entity to serve as the power of direction in order to provide that. And the power of direction could be very specific, where they're authorized to sign only certain documents, certain deeds, etc. Or perhaps it's a general, very general power of direction where they can do almost anything that the primary beneficiary could do. And now let's have a quick word from our sponsor, NNNinvest.com. This episode is sponsored by my good friend Joel Owen with NNNinvest.com. Are you looking to invest in triple net properties but don't know where to start? Perhaps you have a 1031 exchange with pressing deadlines. We all know how that goes. NNN Invest is a leading company in the field of triple net retail investing in syndication in the United States. Their proven 5-part framework not only maximizes the return, but also provides peace of mind before, during, and after the 1031 exchange transaction. Don't settle for less. Start the day at nNninvest.com. That's nNninvest.com. We've known Joel at nNninvest.com for quite some time, so we've done a lot of transactions, a lot of work with him, so I highly recommend him if you're looking for triple net lease type properties. Now let's get back to the benefits of using a title holding trust or land trust to hold title to the property. Now, certainly the most important, the most common use of a title holding trust is confidentiality and privacy of ownership. For example, those individuals who are concerned about litigation. It could be maybe executives or managers or highly compensated individuals. It could be investors, realtors, developers, contractors. You know, you're worried about your name being out there on real estate, on title to real estate in the public records. And if something happens, attorneys can track you down and understand or discover that you've got some assets and you're worth going after. So by holding title inside of a title holding trust, your name is never on the public record. And attorneys hopefully would just say, this person's not worth going after. Let's not worry about it. You might be concerned about privacy issues, such as stalking. So those folks that are maybe in law enforcement, police, judges, celebrities, anybody in the entertainment world, anybody who's had stalking issues before where they've been a victim of stalkers, they may not want their name to be on public record so that whoever's after them or whoever's trying to track them down can't find them easily. So that's another reason why you want a title holding trust, to give you that privacy and confidentiality of ownership. Finally, it might be a situation where you're trying to negotiate and acquire land and you don't want folks to know that you're doing it. So kind of a couple examples there. Probably the most public example of a land trust is Disney. Walt Disney decided to open Disney World in Florida. Can you imagine what the real estate values would have done if people knew that Disney was going to Florida? Everybody would have jacked their prices up to unbelievable levels, and he would have had to pay those. So he used a combination of multiple Florida land trusts to actually negotiate and acquire the land he needed to ultimately build Disney World. That's a perfect example where you need confidentiality and privacy during the negotiations and the actual acquisition. We've had clients who've said, I want to buy my neighbor's property. It's now for sale. It's listed on the public records, but my neighbor doesn't like me at all. And if they know that I'm the buyer, they won't sell to me. So again, you could negotiate and acquire through the title holding trust. So there's a lot of benefits there from a confidentiality and privacy of ownership perspective. And that by far is the most common reason people use the title holding trust. We're going to go into a number of other benefits that a title holding trust provides you. And then after that, we're going to go into what it does not do, which is almost as important. There's a lot of misinformation out there on what you think it can do, but it really can't do. And so we'll cover that as well. So first, let's compare a title holding trust to a living trust. Again, like I said before, the living trust, let's say you've got husband and wife, they're the trustors or grantors, they set up the living trust. They name their kids as the beneficiary, and the kids have a future interest upon the death of their parents. We talked about the fact that the title holding trust was different in that area because the trustors or grantors who set up the title holding trust are probably going to be the primary beneficiaries as well, because that is the issue. That's the entity. That's the person that has a current interest in the property. The primary beneficiaries of a land trust really own the trust today. It's not a future interest like it is with a living trust. So with a title holding trust, the trustee holds legal title to the property, but they only hold legal title to the property. With a living trust, the living trust also holds title to the legal title, the equitable interest or title, and the beneficial interest or title. So with a living trust, the trustee holds all three of those real property components, the legal, the equitable, and the beneficial interests, where with a title holding trust, the trustee only holds legal title. They do not own equitable title. The beneficiary, the primary beneficiary, owns the equitable title. And I emphasize that. And why do I do that? The the beneficial interest is considered to be personal property, not real property. So that gets really technical. But what it means is if you are going to acquire real estate, and instead of taking title in your individual name, you take title through a title holding trust. What you have done is converted that interest, that real estate purchase, from real property to personal property. It's not considered real property for trust purposes. It's still considered real estate for tax purposes. You still get all the benefits of owning real estate, but for trust purposes, it's personal property. That's extremely important. We'll talk about that in a minute as to why that's important. Let's go into avoidance of probate and administration of the title holding trust. So first off, if you are a resident of a specific state, you buy real estate in that state. If you buy it in your individual name and then you pass on, almost every state has some type of a probate process or probate laws. So that property has to go through probate, and the state determines who inherits the property. To avoid that, you're going to set up either a living trust and or a title holding trust. A title holding trust will bypass probate just like a living trust will. So you set up the trust, you're the trustor, you name yourself as the primary beneficiary, you name your kids as the successor beneficiaries. God forbid something happens, but you pass on, your kids or whoever you name as successor beneficiary will immediately receive the beneficial interest of that trust, will immediately have the ownership rights and responsibilities and benefits and burdens of ownership of the property without having to go through probate. So it bypasses probate. So that is key. It also allows you to avoid ancillary probate. I know some of these topics get kind of technical, but ancillary probate is, well, let me use myself as an example. I'm a California resident. Let's assume that I own California real estate and I put it into a title holding trust. I pass on. My daughter will inherit the California real estate and it will bypass probate because of the title holding trust. What if I go to Arizona and I buy some rental property in Arizona and I don't take title to it in a title holding trust? Because it's Arizona real estate, when I pass, that property is going to have to go through Arizona probate. It's what they call ancillary probate because it's real estate. Instead, if I had bought that Arizona property in a title holding trust, I have converted it from real estate to personal property. I no longer own real property. The trustee owns real property. I own the trust, which is a personal property interest. I have now avoided ancillary probate in the state of Arizona. So it's a huge estate planning opportunity when you own real estate in various states. Talk to your attorneys and CPAs about that and discuss the issue of what happens if you own real estate in other states, what happens when you die, and are you going to be subject to that ancillary probate? So there's a lot of estate planning issues that you can use a title holding trust for. One of the questions we get a lot right off the bat is, well, wait a minute, I already have a living trust. My wife and I have set that up. We've named our kids as the beneficiary. So can't I use that trust? The answer is yes, that's a possibility. But that trust is going to be located in the state in which you live. And if you own real estate in another state, you've got that ancillary probate to worry about. So what you can do is use a title holding trust to acquire and hold legal title to the property in the other states. And instead of naming your kids as the beneficiary under the title holding trust, you can make the primary beneficiary your current living trust. So it folds very nicely right into your current living trust, your current estate plan. So it's a really nice kind of trust that integrates right into your existing estate plan or your living trust. It's also very easy to transfer ownership. With a title holding trust, you are the beneficiary of the trust. As a beneficiary, you can assign all or some of your interest in that trust. For example, if you decide to sell the property and the buyer is just as concerned about privacy of ownership as you are, instead of recording a deed, you can go through the closing process just like you would normally go through the closing process. But instead of recording a deed to convey title, you would assign all or some of your primary beneficial interest to the buyer. The buyer then becomes either the 100% primary beneficiary, or maybe there are two of you are going to go in together. Maybe they buy a half the property. They buy a fractional interest. So you can have any kind of percentage split you would like. Maybe you want to slowly gift the property to your kids or your grandkids. In most cases, to do a gift, you have to figure out what is the value of the property. And if you're going to limit it to the $15,000 per person per year gift rules, then you have to calculate what is the value, and then you have to calculate what percentage of the real estate, which is a very small fractional percentage, is equal to $15,000, and then you record a deed from the trust or from you to your kids. With a title holding trust, all you have to do is calculate the value, calculate the percentage, and assign a percentage of the beneficial interest to your kids. And there's nothing recorded, there's nothing on title, so they maintain the confidentiality of ownership. So there's lots of ways where it makes it a lot easier to convey title using a title holding trust. Let's go into a few other benefits. Let's assume that you own real estate, maybe your primary residence, also some rental property, and you're concerned about litigation, other risks of a property ownership. You're concerned that you might get sued. Maybe it's a multifamily property, you got a lot of tenants. So in a lot of cases, if you get sued and you lose, the liens or the judgments related to that litigation can attach the real estate. In the future, when you go to sell that property, you can't sell it without somehow releasing or satisfying the liens or the judgments against the property. With a title holding trust, you've converted, remember, this goes back to the personal property issue, you've converted your real property interest into a personal property interest. Liens and judgments can no longer attach to the real estate because you don't own the real estate, the trustee does. So the trustee holds legal title to the property, therefore you're not the owner, they can't attach the lien or the judgment to the real property interest. Now they can, if they find out about the title holding trust, attach your beneficiary interest. But that means in the future, you could sell the real estate. And let's assume that there's co-owners. Maybe there's 10 of you that went together as co-investors. You bought a large multifamily property, and to protect each other from this type of issue, from this litigation, you used a title holding trust. Let's assume one of those co-investors gets sued, loses, and has some kind of a judgment against that person. That judgment can only attach their individual beneficial interest in the trust. It cannot attach the real property interest. So now in the future, when you go to sell that property, you can still sell it. The lien or the judgment will not hold up the sale because it's not attached to the property. Now, as trustee, we would have to hold the proceeds that relate to that one beneficiary, that one owner, but the other 9 owners in that example can receive their proceeds and go on. So it's a great way to protect co-investors from other investors' liens or judgments or whatever else might happen there. Similarly, it's the same type of issue with clouds against title, whether it be a death, a divorce, a bankruptcy, settlements, things like that. Federal taxes, local tax liens. With a title holding trust, they cannot attach the real estate unless it's directly related to the real estate. For example, property taxes run with the property. If there's unpaid property taxes and there's a lien or a tax lien certificate, that's going to affect the title to the property. But if it's a lien or a judgment or a tax issue related to an individual, it cannot attach the real estate. It can only attach the beneficial interest in the title holding trust. At the same time, going back to my example of the 10 co-investors, one of those investors may decide they want to sell for whatever reason. The other 9 investors may disagree and object. The one investor, if you own the property directly, the one investor could either issue a partition action or a charging order and go to court and force the sale of real estate. Now, if you held title to that in a title holding trust, petition actions and charging orders are very difficult, if not impossible, against a personal property interest. So again, that's why that personal property interest is so incredibly important. It solves lots of potential issues, especially when you have co-investors. Speaking of co-investors, if you have, again, let's say 10 co-investors, and you decide to refinance the property or transfer the property or sell the property or exchange the property, you're going to have 10 individual signatures on any documents required to sell the property, to open the closing, to open escrow, to sign loan documents, etc. With a title holding trust, the 10 investors would authorize the trustee to execute documents, and then every single thing that has to be executed only requires one signature, the trustees. So when you have multiple owners, especially sometimes you get families who have 10, 15, 20 family members that own real estate, it makes the execution of documents much more efficient, much more streamlined for all of the executions, any of the transactions you might do. There's no state filing requirements, so you do not have to file, and in fact, you don't file. There's no way to file with the Secretary of State, and there's no Secretary of State or state taxes or state filing fees. So for example, I'm in California. If I use an LLC, there's a minimum LLC tax of $800 per year. With a title holding trust, there's no filing with the state of California. There's no $800 per year. But let's talk about some very specific tax issues when it comes to a title holding trust. So I mentioned at the very beginning that a title holding trust is a pass-through entity. That's critical. Means anything that happens inside of that trust for tax purposes gets allocated to the beneficiaries. If there's one primary beneficiary, 100% of the tax consequences gets reported on that beneficiary's tax return. If there's 10 beneficiaries, they can all own different percentage interest in the property. So each of them would have a different percent beneficial ownership position. The tax consequences would be allocated to each primary beneficiary based on their percentage ownership in the trust. The title holding trust is also a disregarded entity, which means it exists from an estate planning perspective. You get all the benefits of the grantor trust, but it's ignored for tax purposes. And that's a critical issue, and this is why. So the questions we often get at this point is, well, if I own real estate, and let's say it's rental property inside of a title holding trust, and I decide to sell that, can I still do a 1031 exchange? Absolutely. In fact, there's a specific IRS ruling that talks about a Delaware statute, or sorry, the Illinois statutory trust, where the Illinois Land Trust is considered to be real estate for tax purposes, which means you can sell that and you could do a 1031 exchange. If you own your primary residence in a title holding trust, you can still get the Section 121 exclusion, or the 121 tax-free exclusion. That's the $250,000 or $500,000 tax-free exclusion on the sale of your primary residence. If you own it in a title holding trust and the government takes your property through an eminent domain, or what we call an involuntary conversion, you still qualify for a 1033 exchange. If you sell the real estate and decide that you're going to do a seller carryback note, you could still do the seller carryback note. You could do that through the title holding trust and have payments made to the title holding trust, or you could pull it outside of the title holding trust at that point and have the payments go directly to you. So you really don't eliminate any of the tax benefits because it's a pass-through entity, and most importantly, it's a disregarded entity. So with that, let's kind of compare a title holding trust to an LLC, because that's really kind of the two offsets. The issue breaks down to risk management, liability protection, and confidentiality and privacy of ownership. And there's a lot of confusion here. So what does a title holding trust do versus what does a LLC do? So first off, the title holding trust, again, it's designed for confidentiality. It's designed for privacy. So that gives you a limited amount of asset protection. In theory, if something happens and an attorney is looking at the case and trying to decide if you're worth suing, if they can't find your name on legal title to any property, then you may not be worth suing, and they hopefully drop the case. So that's the limited asset protection, really. But beyond that, there's no asset protection. It really just gives you the confidentiality of ownership. With an LLC, of course, you're going to have moderate asset protection. As somebody sues the LLC, it protects the rest of your estate. So it really depends on what the issue is, why they're suing you, how they're going to go about that. So there's liability protection with an LLC, but you generally don't have confidentiality or privacy of ownership with an LLC like you would with a title holding trust. Now, obviously, there's 50 states, there's different rules, different laws in each state. So you have to talk to your attorney to find out what state's best for you. Is an LLC better? Is a title holding trust better? Etc. In some cases, we have folks who are very, very concerned about liability and risk management because they hold maybe many units and they're just concerned that it's not will they get sued, it's when will they get sued. In that case, we've seen individuals use both, where the title holding trust is established and owns title to the real estate, and the primary beneficiary is named as the LLC. So you have confidentiality of ownership, then you have liability protection, and then you would be the sole member of the LLC. So there's lots of ways to stack it, but be careful not to get too complicated. Some of the seminars out there have you get all of these layers to protect you, and then when you go to refinance or 1031 exchange the property or something like that, you find out you've created a nightmare. So it's a difficult thing to look at, but you have to really try to analyze what is your risk, what's your risk of litigation, et cetera, and then what type of protection do you think you need, and just don't go overboard. Sometimes just really good insurance is all you need. Now, I mentioned those are all the benefits of the title holding trust. I mentioned we're going to talk about what does it not do, and this is probably just as important because there's been a lot of abuse with land trusts out in the industry today. You're going to find that some lenders will not lend because it's a trust. Some lenders will not lend because it's a land trust. Title insurance companies, in a lot of cases, don't want to insure title when it's held in a land trust because of all the abuse that's happened. In those cases, it's easier to get title insurance and maybe easier to get a loan when there's a corporate trustee because they know we're not going to jeopardize our trust charter. But let's kind of talk about, what does it do? What does it not do in terms of these specific topics that I'm going to bring up? So first of all, with a title holding trust, does it minimize litigation or anything like that? Absolutely not. It does not minimize the risk of litigation. If you are sued, at some point, the court is probably going to have you disclose all of your financial holdings. You're going to have to disclose the existence of the title holding trust. So once you're sued, there's really no liability protection with a title holding trust. So that's important to know and understand what it does. It does allow you to pass all the tax consequences through to your tax return, as we talked about, but it will not avoid taxes. So there's a lot of misinformation out there where they say, use a title holding trust, and when you sell, it will not be a taxable event. It's not true. If you sell property, it's going to trigger any of the taxes it would trigger if you held title in your individual name. Let's get specific on that. So one of the areas that folks will talk about is due on sale clauses. And they'll say, if you're the seller, put your property into a title holding trust. The fact that you are the owner and you're the primary beneficiary of the title holding trust, it cannot trigger the due on sale clause. Then sell the property and transfer or assign the beneficial interest in the title holding trust to the buyer, and it will avoid the due on sale clause. In most cases, that is not true. The assignment of the beneficial interest is considered conveyance of title. It's conveyance of title for tax purposes. It's conveyance of title for trust purposes. So what they're really telling you when they say that is do that to avoid the due on sale clause because nobody will know. And the issue is it doesn't matter. It's wrong. It does trigger the due on sale clause. In fact, a lot of the loan documents I've read today will have language that says any conveyance of title to a third party. Well, any conveyance includes an assignment of a land trust. Some of them even mention land trust. So it's all going to be driven by what the loan documents say. So when they say use a title holding trust to get around the due on sale clause, go back to the loan documents, read the loan documents. In most cases, the title holding trust will not work. In fact, if you use it for that, it could very well be lender fraud or loan fraud because you've fraudulently conveyed title to avoid the due on sale clause. Next area is seasoning. So there's certain requirements and they change all the time. But in certain times, like during the 2008 recession, you had to own the property for a certain number of months before you could refinance the property. So what people would do is they would put the property into a title holding trust, then sell the property and assign the membership interest, or the beneficial interest to the buyer. And they would say, well, the trust has owned it for over 4 months or 6 months or whatever the requirement was at that point in time. But that doesn't matter. You've conveyed title by assigning the beneficial interest. That's conveyance of title. So technically the seasoning starts all over again. So what they're really telling you is it's not on public record. They won't know about it. But if they somehow discover that, it's probably lender fraud. You have to hold title. You have to season it in your name, whether it's through legal title or as a beneficial ownership interest in the title holding trust. But straddling two different owners through a title holding trust will not lengthen the seasoning requirement. The last one is reassessment for property tax purposes. It's amazing how many people will try to put the property into a title holding trust and then sell it and assign the beneficial interest to the buyer, and then it does not get reassessed for property tax purposes. That's absolutely not true. The conveyance of title has occurred. The assignment of the beneficial interest is a conveyance of title that will trigger the reassessment for property tax purposes. It's not on public record, but you are required to notify the county of that transfer. So it is tax fraud if you use the title holding trust to get around that. And I know there's people out there who love to do this, but I'm just telling you, be careful, because it's not what the title holding trust was designed to do. Let's talk about contributing the property into the trust and when should you do that. That's what they call funding the trust. You deed the property into the trust, you've funded the trust. The question we get is, I already own a bunch of property. I own my primary residence, I own rental property. Should I set up a title holding trust and deed that property into the trust? At that point, you're not really getting much benefit in terms of confidentiality or privacy of ownership. Because at that point, you've been on recorded title. And a lot of the jurisdictions today, the local counties, states, what have you, have all of the property records on some form of internet-based search function. So you could probably go down to the county or log in online if you have the right account and do a grantor or grantee index search. And in most cases, that will tell people that you used to own property located at 123 Main Street. So you may not currently own title. You may have deeded it into the trustee's name when you set up a title holding trust. But they're going to be able to tell that you did own property at one point in time, and it looks like you conveyed title into the trust. They're going to assume that trust is yours. So if you already own the real estate, you don't get a whole lot of confidentiality and privacy benefits. It may help if you've got a lay person who really doesn't know how to search property records. They may search for current title and they're not going to find you, but that's about it. So if you're looking for the other benefits of a title holding trust, you can convey title into the title holding trust at any time. So if it's the lien and judgment issues, co-investor issues, things like that, you can get that benefit at any time. If you're looking for the privacy and confidentiality benefits, you really need to have the title holding trust acquire and hold title at the date you actually acquire the property. It should never go into your name. Otherwise, you really just don't get that benefit. Part of our job is to review all of the documents, so the purchase and sale agreement, any property tax records, the DTT, preliminary change of ownership form, things like that, and make sure your name is not going to show up on recorded title when the purchase of the property closes. That's critical. You have to make sure that the trustee's name is everywhere and the individual owner's name is not going to be reflected as an owner of the property. There's going to be environmental issues, perhaps. So any trustee is going to want information on the property. There'll be probably an environmental or indemnity, an environmental questionnaire, things like that. They're going to want evidence of insurance that the trustee is also named as an insured because they really own the property. So that's key. Let's talk about financing the property real quick as well. So a lot of lenders will not lend to a trust of any kind. So whether it's a living trust, a title holding trust, or other, lenders are concerned that two things really. They're concerned, one is they may not be able to sell that loan in the secondary market. So they're concerned that if they get stuck with that loan, they can't sell it. So they're concerned that if they put it in a title holding trust, that may prevent the investor from buying the loan. So that's the first area. The second area is they're worried if it's in a title holding trust, does that complicate a foreclosure process? If there's a default on the loan, is it going to hold up my foreclosure efforts? Really, the answer with the first one is it depends on who the investor is. But in most cases, I understand that risk. So if it's a conduit lender, they're probably not going to make the loan. Conduit lenders are those like a B of A, a Wells Fargo, Chase, that make the loan and sell it off in a package to investors. And they're just not going to touch it because they don't want to take the risk they get stuck with it. If you get a portfolio lender, a small bank, a community bank, a local regional bank, where they make the loan and keep it in their portfolio, they're more likely to take a look at this, especially if you have an existing relationship with the bank. So that's key. The lender's going to do the underwriting on you as the investor, not us as the trustee. We're just holding legal title to the property. We're going to sign the promissory note. They may have you sign the promissory note. They may have you sign a guarantee. They'll have us sign the deed of trust or the mortgage, but you're really the borrower. So they're going to underwrite you when they're going through the underwriting process. They'll just have us sign all the documents because we're holding legal title to the property. So again, conduit lenders probably won't touch it. Portfolio lenders probably will take a look at it, especially if they're a bank that really has a real estate focus. They'll take a look at it. Hard money lenders, private money lenders will look at this all day long. You could also pledge the beneficial interest in the trust to a lender. It does not create any problems if you pledge the beneficial interest. Let's talk about the role of the trustee. So again, as I mentioned at the very beginning, the trustee does not have any discretionary authority. The trustee merely holds legal title to the property as part of the title holding trust. They can't do anything until the primary beneficiaries give them direction. So first of all, the legal vesting is going to be something like Exeter Trust Company as trustee of trust number 123456. Again, they have no discretionary authority, so the primary beneficiaries have to authorize them to sign deeds, deeds of trust, mortgages, whatever it might be. If there's leases involved and they want confidentiality on the leases, you would have the trustee sign the leases as the landlord, but you have to authorize them to sign that. So any type of a note, a deed, a lease, etc., would have to be authorized by the primary beneficiary, and then the trustee would execute based on the direction provided by you. If anyone wants information on the trust and you want to provide that as the beneficiary, we can issue a trustee certificate that can disclose whatever information you want us to disclose. It can disclose things are, we certify the following, that the trustee is currently in full force and effect, the trust exists. We generally would not disclose anything about the beneficiary unless you need us to, for whatever reason, whether it be a loan process or something like that. So thank you so much today for listening to Go Ahead Ask podcast. Our next episode is going to be unraveling the mystery of net lease properties, often referred to as triple net lease properties. We're going to be interviewing Joel Owen, who's our sponsor today with nnninvest.com, and he's going to spend almost an hour going through a lot of detailed information on net lease properties and how you might want to get involved with those. So for today on Go Ahead Ask, don't forget, send questions. If you have a topic you'd like us to cover, email it to us. If you want to actually show up on our podcast, email us at ask@exeterco.com. Or you can call us at 619-239-3091. Again, that's 619-239-3091. If you like our podcast, please like it, subscribe to it, and share it. You can find us on all of the various social media applications. Thank you again for attending and listening to our podcast today. We'll see you next time.
Thank you for listening to Go Ahead Ask with the Exeter Group. Join us for our next episode when we further unravel the mysteries of real estate.